I've got PR on a child that's not my daughter. The child lives with me. Mum's trying to get me to pay for the activities while she's with her.
What a darn cheek. You're raising the child. Whatever mum chooses to do is totally her responsibility.
The court dismissed his 50%. He's rejecting the one overnight stay. He's rejecting everything the Cafcass lady advises or says.
If you and your ex can't agree and he disagrees with Cafcass, that's not really your issue.
Is it only contributions made during the marriage that are considered in the financial order?
If you have lived together before you got married, we are going to count the years of cohabitation. Hi everyone and welcome back to the Legal Queen live show. I am your host Tracey Maloney, aka the Legal Queen. I'm also a practicing family law solicitor and have been now for over 20 years. What you're about to hear is people who phone me on my Discord channel and ask me a question around family law. That could be anything from divorce through to finances and the all-important child custody matters. If you have a question that you think I could help you with, then by all means please join me on Discord. Come into the Legal Queen Lounge, pop your hand up and I'll get to you as soon as I can. I hope you enjoy the show.
I've got PR on a child that's not my daughter,
Yeah.
and it's my husband's. Me and my husband have now split up,
Yes.
but the child lives with me.
Yes.
And basically she has contact with both her mum and her dad. Her dad has 3 hours a week, her mum has 2 hours a month.
Yes.
That was decided via courts. But mum's trying to get me to pay for the activities that they do while she's with her.
Okay.
Who has to pay for that legally? Because I can't afford any extra, and then she only gives me £7 a week. Well, just under £7 a week in child maintenance.
Yeah. I mean, look, legally, there's no law around that. But I think common sense will tell us that whatever mum chooses to do for the 2 hours a month is totally her responsibility. So if she wants to take the child for a coffee or a McDonald's or whatever it might be, she's paying for it. You know, if she wants to take her to the cinema, she's paying for it. That's what mum needs to do. I mean, my goodness me, you're raising the child on how much? £7 a month? Is that what you said?
That's what she gives me, yeah.
That's you know, so I think it's
Oh, no, £7 a week, sorry,
£7 a
under.
week. Oh yeah, that makes a huge difference. But I think, you know, what a darn cheek that then when she has her 2 hours a month, she expects you to pay for the activities. No, you can put your foot down there and say, absolutely not. What you do in the 2 hours is completely up to you. You know, mum has free reign to spend what she likes or not, as the case may be.
So the other spin on this is she's one of 5 children.
Yes.
The child that I've got in my care.
Yes.
And mum said that she can't, so all the children get together,
Yeah.
and as the child that I've got is very fluctuating in behaviours and just gets overwhelmed very easily.
Yeah.
I also stay for the contact with mum slash sibling contact, whichever
Yes.
way you want to put it.
Yeah.
Basically says that I get child maintenance from her, and I get child benefit, which I claim, and I should be using that on
No.
her time.
Absolutely not. The child maintenance and the child benefit is for the benefit of the child. And that
But
includes...
that's my argument.
Yeah, absolutely. That includes heating and feeding. And not only that, because you are the main carer of that child, court ordered, by the way, it's at your discretion how best to spend that money, not mum's. You know, mum can't dictate to you when she only has 2 hours a month how you allocate your child benefit or your child maintenance or whatever it is that you're in receipt of. That's your power, if you like. That's your decision to make. So no,
Because the other argument I have
Yeah.
is obviously where she has contact with her dad for 3 hours a week as well.
Yeah.
Anything that I do for her, I then have to do for him as well, if you know what I mean.
Well, exactly. And, you know, I just don't see the logic in mum saying to you, well, when I have the child, you have to pay for the activities that we do. I just don't see the
Yeah, she's like, I
that just
can't
doesn't
afford
happen.
my 5 children to do it.
Well, you
So,
know, that's not your problem. That sounds like a her problem to me. And,
okay,
you know,
the social worker is in support of me paying, and I'm like, I'm not doing it. I've
no.
refused.
No, I think potentially, yeah, social services maybe don't really want to get involved and are just trying to ease the tension a little bit. And maybe, look, maybe biological mum is struggling financially, but you are
So am I.
raising exactly, and you are raising her child, so you have a much bigger burden of responsibility. And no, I think just stand your ground, Amy. You know, as
So
nice as you may want her to think you are, no, when it comes down to the children, you're making the best decisions.
okay. So when it comes to like they want to do like the Wonderland sort of activity play role village things,
Yeah.
um, if I take her, because the court order says I have to make her available for contact.
Yes.
If I take her but refuse to pay,
Yeah.
what would happen if mum also refused to pay? Do I then take the
Oh,
child away?
I know that what an awful position, because now here we are at Winter Wonderland with a child who's as giddy as anything to go in, and both parents are saying, well, I'm not paying, well, I'm not paying. And I would be tempted there. I don't know if the order is specific in that you have to take her to the event. Do you? Do you have to take her to the event? Do you have
Well,
to?
mum doesn't drive, so
Okay.
I use my fuel and get her there, etc.
If it were me, and this isn't legal advice at all. This is just a suggestion. If it
Sorry.
were me, no, it's fine. I would be suggesting to biological mum that I will only take her there on the condition that you are paying for her to get in, because I'd be thinking about the child. I don't want to get there and then have a disappointed child. I'd end up paying, and of course, that's exactly what biological mum wants. So I think that you're going to have to get mum to say, absolutely, I'm going to pay, or she gives you the money up front. Do you know what I mean? Something, but I'd be thinking about the child there. I wouldn't risk it. I wouldn't risk it.
Yeah, because I have emailed, corresponded with mum, vice versa, saying that I'm happy with doing contacts. I'm not going to stop her,
Yeah.
etc. But I'm not willing to pay. But where we live in two different towns, the brother's SGO holder picks her up and takes her over when it's in our town.
Yes.
And then I drive her down to where mum is every other month, if that makes sense.
Right. The other option,
So
the other option is you could drop the child at mum's house potentially. I don't know if that would work, and then you're.
unfortunately, that's not able to happen,
Oh.
due to the social workers not wanting that to be
Ah.
the case.
Okay. Okay. Yeah.
Because she has got one sibling that's gone back to mum
Right.
after 4 years in care, and she doesn't wanna
Wow.
upset my little one knowing that she's back at
Oh, I
mum's and she's
see.
got all of her stuff there, etc.
I see. Yeah.
It's such a complicated situation.
It is, isn't it? It really is complicated, that. I mean, look, if it's a one-off, you might want to concede and just think, fine, rather. As I say, my concern is for the child. I just don't want the child to get
Yeah.
there and then be disappointed. And I know that you're not going to let that happen. So if you can avoid taking her there because you think actually mum's not going to pay, that might be option number one. If you want to concede it on that occasion because it sounds like a pretty big deal, maybe you
Yeah.
do pay.
But this does happen every month. She chooses an activity and then,
Oh, really?
like, yeah, so, okay, so basically, on my terms is for the big event like that, I would be willing to, you know, let her go and I will pay out if needed, etc. But I don't want it to happen all the time. But if it
Exactly.
continues,
Yeah.
where do I go from there?
Well, look, if it continues, then obviously, it jeopardizes mum's contact with her, doesn't it? Because
So
you
would I have to go back to court at that point,
I
or
don't
would it be
I don't I don't think you do. I think that you could say, look, I'm really sorry. This has happened 2, 3, 4 times. I'm not willing to make her available for contact now because it's costing me and I can't afford it anymore. So I'm not going to be able to take her for contact. Unless you want to come and pick her up, then I'm not willing to make her available because I simply can't afford to do that. Yes, are you in breach of the order? Yes, you are. Can mum then take you back? Yes, she can. But, guess what the conversation's going to be when we get back before the judge again? It's one of fairness, isn't it? And not having a disappointed child all
yeah.
the time.
Well, like I said, I'm not disputing that she's allowed contact. I'm perfectly fine with that, and obviously she needs to see her siblings as well because that's
Yeah,
important to her.
yeah,
But like I said, it's just a financial aspect.
yeah, absolutely. Absolutely. Well, good luck
All
with
right,
that, Amy.
all right. Thank you. And so sorry, it's a bit of a funny one.
No, 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 pleasure. I like the more interesting ones. Thanks again. All right then.
Thank you. Bye bye.
Bye-bye. Jack, I can see that you've joined me on the stage. Whenever you're ready, take yourself off mute, Jack, and ask me your question.
See,
Hello.
I'm going. I'm going to a final hearing.
Yes.
Um, you may remember from previous times we've had back and forth, and
it's been a bit of a mess, all of it. I'm not represented anymore.
Okay.
So just kind of like, how does a final hearing work when you're not represented?
Well, were you represented at the last hearing, Jack? Did the court know that you were a litigant in person, or did you still have representation then?
I had representation then.
Okay.
I've just been given my notice of change.
Okay.
So I've just got to sign that through DocuSign.
Okay.
But I'm just basically, so it's just trying to work out like how communication looks like. Who do I have to go to? Is it like solicitors or?
What do you mean? Who do you have
like,
to go to? What do you?
Like I've been told that like at 9, like we've got to arrive an hour earlier.
Oh, I see. Actually, yeah. So, you will arrive an hour earlier because the court's hoping that people will enter into negotiations and see if they can't remedy it while they're at court. So, yes, arrive an hour earlier and see if you can't find the other side solicitor, or they most likely will have a barrister if it's the final hearing. Okay, so just check. Okay, so just have a conversation with them. You won't obviously have any kind of conversation with the barrister whilst you are in front of your ex. It will be done in private away from your ex, okay? So make sure of that. Then typically what happens is cross-examination will happen at a final hearing, and that's why I said, did the judge know at the last hearing that you weren't represented? Because what they will do is they will give you permission to file the questions that you want to ask of your ex, and the judge will ask your ex those questions. So you may have to do that, make inquiries with the court so that you can file your questions with the judge, okay? Because you won't be... Sorry?
Is that the QLR?
So the QLR is a qualified legal representative. They will be appointed for you if you have one or if they have one available. If that's the case, then you don't need to prepare questions. They will ask questions on your behalf.
So for the remote hearing, how does that work? Do you just join like a link?
Yeah, the court's gonna. Yeah, the court just uses Teams, and they'll send you a link prior to the hearing, and you'll just log on, and everybody will be on the screen. It's a usual Teams hearing. Yeah. It's unusual for a final hearing to take place via Teams because obviously cross-examination's going to take place. That's hard to do via Teams. So I'm surprised that it's being done remotely. But there we go. That's the court's decision. But if you've got a qualified legal representative, I mean, you won't be turning up an hour early then. I wouldn't have thought, because no one's going to court.
Yeah. No, this is what I said, but they said that apparently I've still got to do 9 o'clock, like that day, because it's at 10 o'clock.
Oh, maybe what they want is for everyone to actually get on the Teams call so they can make sure everybody's there on time, as opposed to doing, because you can't negotiate on a Teams call. Well, I suppose you could go into a private room, but I think it's overcomplicating it. Anyway, you'll be fine, Jack. If you've got a QLR, then they'll look after you.
Okay.
All right.
Thank you so much, Tracey.
No problem. Good luck, Jack. Bye. Ansi, I'm going to come to you. Let me just take you off mute. Whenever you're ready, what's your question?
Yeah, you can hear me.
I can hear you, yeah.
So I don't know if you remember, but I'm under this, we're under this monitoring order by Cafcass.
Yeah.
And so she can take us back to court whenever she thinks that. So how the contact, I think I spoke to you last time about, the father is being not responsive and all these things. Now he's way more responsive than he used to be before. So now we are at a stage where he's going to take my son for one overnight stay and then, gradually, making his way up. However, the court dismissed his 50% of custody. I know you don't call it this way these days, but they dismissed it. So my question is, he clearly wants 50% of custody, like time spent with my son, because he only works 26 weeks out of a year, and he puts down his proposal as being those days, so the whole 26 weeks. So that is a 50% time spent. So I don't know what to do, because obviously he's rejecting the one overnight stay, he's rejecting everything the Cafcass lady advises or says. He doesn't show involvement. He doesn't want to be involved in the nursery. He just says it's not compulsory, so I can take him out whenever I want. But then he raises concern that my son is not speaking yet fully, because obviously he's learning 3 languages, so it's not going to hit in at 3 years.
And
So my question
sorry,
is,
what is your question?
So my question is, obviously, I'm going to go back to the Cafcass lady, but I don't know what to do, because I really just want to advise to go back to court, and the court will the court give us like a set schedule, like around his shift pattern?
Sorry,
Because
Ansi, I'm not understanding what the problem is. So Cafcass have made a
the
recommendation. Let me just repeat it back to you to make sure
Yeah.
I've got it right. So Cafcass have made a recommendation which your ex doesn't agree with. Is that right?
Yeah,
So if you and your ex can't agree and he disagrees with Cafcass, that's not really your issue. The matter is going to go back to court, I would have thought, because you haven't had your final hearing yet, or have you?
I did. So this monitoring order is actually the Kafka's lady is acting like a mediator. So she's trying to, come to like a solution. But yeah, so
A
I don't
final order was made, but then it was passed over to Cafcass to mediate.
kind of, yeah.
Okay.
That's what it is, I think.
Well, then it has to go back to court. I've never heard of anything like that. I mean, if the matter's before the court,
I
it must
don't.
be decided. It's got to be decided upon. And if it's not decided upon, then I don't understand why a final order was. I don't understand, Nancy. I'm sorry. I just don't understand that.
I don't understand either.
Okay.
So if
You're gonna
if he doesn't agree with Kafka's,
yeah, but
then
that's not your problem, is it? Because he doesn't agree with Cafcass. That's a him problem. That's not a you problem.
okay. Yeah,
So,
true. Thank you.
Yeah, no, that's fine. What I was going to just add to that, Ansi, is that obviously if things start to get a little bit hairy again, you might need to just take a one-off advice and show a solicitor the order that you've got and see if they can't shine some light on it for you.
Is it only contributions made during the marriage that are considered in the financial order? And does that include periods of separation?
It will be only contributions that are made during the marriage unless you have lived together. If you have lived together before you got married, and there's a seamless transition, I know that's a bit of a fancy way of saying you lived together and then you got married, but if there's a seamless transition into marriage, we are going to count the years of cohabitation. And in some relationships, that can be quite lengthy. I do a few divorces where people say, well, I've only been married for 5 years, but we've lived together for 20. So it would be the whole 20 years of contributions to the pension that we're looking at. It doesn't really matter about terms of separation if you are still legally married. That happens as well, where people say to me, we've been separated for 5 years, but if you're still married, then that your ex or your spouse has an entitlement to a share of those 5 years contributions. So you've got to be careful, guys, when you've got pensions, and you've got to protect them.
This caller also had a follow-up question.
Yeah.
What happens if you're already drawing a pension?
So when a pension's already in drawdown, it can be difficult to get the actual value of it. That's the first obstacle, because it's changing every month. But it still is a matrimonial asset. So if we're not able to divide it, and usually we are, but we will look to see if there's another asset that we can maybe make an adjustment with. But we can still do a pension share on a pension that's in drawdown. A little bit more tricky, but it's still possible.
My ex is currently on bail due to DV allegations. They have said the family court procedures can go ahead as normal, but he's making threats through my solicitor to not dig a deeper hole for myself. Should I report this to the police as witness intimidation, and would this help my non-molestation application?
Absolutely. I mean, if you are genuinely feeling intimidated, scared, frightened, harassed, bullied, any of those things, absolutely report it to the police. If there's a need then for a non-molestation order, that's your evidence that, you've had to report it to the police, or you've been to your GP to seek some help for the stress that you're under because you're being harassed and intimidated. So yes is my answer to that. It's hard to make make a judgment call when somebody's telling you something like that. You know, it goes on how the other person's making you feel. You know, what scares me might not scare you, Captain. Do you know what I mean? So it's always subjective to that individual. If you are feeling harassed, intimidated, as I said, all of the above, absolutely report it to the police.
How can I get to see my 16-year-old daughter if their mum won't let me?
So 16 is key because obviously too old now to make an application to the family court. Children's orders kind of fall away once the children reach 16, and the court take the view that they will vote with their feet. So if mum is still not allowing you to have contact with your 16-year-old, I would be suggesting mediation. I mean, there's going to come a time when the child reaches 18 where mum's not going to have as much influence over the child as she has now, potentially. But, you know, the thing that I would be reminding mum in this particular example is that you are placing a huge burden on that child's shoulders. Because a lot of children will say, oh, it's okay, I don't want to see my dad or my mom, because they're saying what the parent wants to hear, and it's really difficult. But I would say, in answer to that question, try mediation. And if that doesn't work because the child doesn't want to go to mediation, and I'm not saying that mom has to go to mediation, it's just the father and the child. But if they don't want to do that, then you might have to wait until they're 18 and then reach out to them as an adult, which is a shame.
We talk in finances a lot about fair and reasonable. What is a court's fair and reasonable? Because a court's fair and reasonable is very different to say what the average layperson would think is fair and reasonable.
Absolutely. And it's a great question because obviously we talk about fair and reasonable all the time. The court's primary concern are housing needs. And if we've got children, then the housing needs of the children. So, you know, is everybody reasonably housed? And then the next element is income needs. Does everybody have enough income coming in, whether that be from benefits or salary or what have you, to look after their basic needs? So their housing costs, their utility bills, and of course their food and clothing. And then the last one that we will consider are capital needs. So where a party separate and maybe one person's going to keep the entire contents of the house, does the other person need, let's say, a lump sum of 5,000 or 10,000 to refurnish a new property? So once the court's considered housing needs, income needs, capital needs, it will then look to give a reasonable allocation of the money that we've got available to tick those boxes. So the reason a lot of people say, well, I don't think that's fair because I brought this in and I paid for that and I paid for the mortgage and they didn't contribute and all the rest of it, doesn't matter. It really doesn't matter. When it comes to divorce, the court wants to make sure that nobody's going to get left out on the street and have no money coming in at all.
Yeah, and when you get married, Tracy, what's yours is mine and what's mine's yours, isn't it?
Absolutely. And there's no room for conduct anymore. You know, it's quite sad. I mean, don't get me wrong. I'm glad that we get divorced now and we've got the no blame. I do think it's a far more proactive and healthy way of getting divorced. But I do sympathise with people that say to me, but it's only because of my ex's infidelity or my ex's addiction that we are actually having the divorce. You know, I want to stay married, but they're making it impossible. And that plays no part in the finances, people's conduct anymore. Which, you know, well, very rarely. I mean, it does in exceptional circumstances, but that's difficult to get your head round. And it makes that whole fair and reasonable element a little bit harder to understand at times.
Yeah. I mean, even with the old, because I'm sure there is still people on the old system, isn't there?
Yeah. Oh, 100%. Yeah.
Even when it comes to things like adultery, that's not even factored in. Wasn't even factored in on the old system, was it, when it came to splitting finances?
No, absolutely not. Absolutely not. I mean, adultery, or, you know, I've had cases where one of the parties has just, you know, blown it all at the casino, or one of the parties is, you know, unfortunately has an addiction issue, gambling or drugs or whatever, and all the money's gone. You know, I've even had it where my client thinks that they own the home that they live in, but it turns out that they never did. You know, some really sad stories, and unfortunately the court's only got so many powers. It can only deal with what the parties own. But yeah, conduct we don't use anymore.